Good afternoon all, and thank you very much for joining us. We're just running a couple of minutes late, so we'll wait a very short period of time in case anybody else wants to join, and I'll use that time to make some brief introductions. I apologise for the slight glitch that has us running a couple of minutes late. That is entirely my fault, and my name is Tim Prudhoe, as you'll see, I hope, in the bottom of the screen. With me is my colleague in Chambers, Christopher Loxton. Chris is a senior junior with a diverse practice, but one particularly relevant to the judgment enforcement and recognition issues that we're going to cover today. Chris has worked overseas pre-law. He had a life before being a lawyer, and that certainly is reflected in his practice now. He'll deal with the first part today, a little bit about me. My name is Tim Prudhoe, and I'm an insolvency practitioner as well as a barrister. I'm an insolvency practitioner outside of the UK, and although I'm very much open for business with 3 Hare Court, I spend a lot of my time in the Caribbean, where in some respects, the post-Brexit world that Europe is left with it's been the world that I've been living in for the last 15 or 20 years, because there is so little guidance as to what can be done, how you do it, and the mere concept of mutual recognition is something that we all dream about in the Caribbean. So I'm going to hand over now, please, to Chris, who'll take you through some what may be possibly quite familiar territory, but to give you an idea of where we are at the moment, to the extent that anyone can properly tell that in the European context. So over to you, Chris. Thanks.
Thank you very much, Tim, and my apologies too for the late start. Hopefully it won't be too long before we're not doing this all over Zoom and we're doing it in person. So without further ado, I'm going to kick off with the slides. That's great. So as Tim said, I'm going to be speaking to what the post-Brexit terrain looks like. So we're particularly focused, or I'm going to be particularly focused on what the position is as between the UK, particularly England, of course, and EU member states. Tim's going to then speak, I think more generally as his experience indicates, about enforcement and recognition. And then hopefully we're going to have time for questions. In terms of questions, we're going to leave them for the end, but that shouldn't preclude you, if you have any burning questions, from immediately putting them in the chat function. And then what we'll do is I will have a look at that while Tim's speaking, so that hopefully we can be ready to go with questions and answer them as best we can at the end. So as it indicates, I'm going to talk very briefly about judgment recognition enforcement and then insolvency recognition. And as Tim again said, I'm conscious of who's on this call and listening to this webinar, that a lot of this stuff will be familiar with for you. Notwithstanding that, I think it's important to just clarify what the position was pre-Brexit, Brexit Day, and post-Brexit, so that one can better understand a more general chat and the questions at the end. Okay, so if we go to the first slide, please. Okay, so judgment enforcement recognition in the EU pre-Brexit, and when I mean Brexit, I'm talking about the day itself, namely after 11 o'clock PM on the 31st of December 2020. So, as I say, you'll no doubt be familiar with the fact that the European jurisdiction regime continues to apply for proceedings issued on or before 11 o'clock PM on 31st of December. When I say the European jurisdiction regime, there's obviously 3 parts to that, predominantly the recast Brussels regulation, which applies for proceedings instituted on or after 10th of January 2015. The 2001, not 2012, I put there, 2001 Brussels regulation applies to proceedings instituted before 10th of January 2015. And then the 2009 Lugano Convention, which applies up to that date in respect of enforcement of UK judgments in 3 EFTA states, that's Iceland, Norway and Switzerland. The other EFTA state, Liechtenstein, is not a party to the Lugano Convention. And I'll talk about, as we discuss post-Brexit, prospects for joining the Lugano Convention for the UK. So again, you'll be well familiar with the fact that this European jurisdiction regime provides pretty easy, or comparatively easy, certainly in regards to post-Brexit provisions, a relatively straightforward system of enforcement with certificates having to be obtained, and then essentially a judgment can be enforced in a foreign jurisdiction as if it were a local one. And then on to the next slide, please. So what is the provision post-Brexit? Essentially from the 1st of January 2021, well, of course, the European regime doesn't apply. That then begs the question, what is going to happen about the UK joining the Lugano Convention? I'm sure all of you on the call will be well familiar with the fact that the UK has made efforts to join it. That's been met with favourable decisions from all the 3 EFTA states of Iceland, Norway and very recently Switzerland. But perhaps predictably on the 4th of May, the European Commission made a recommendation that the EU should reject the UK's membership on the basis that the convention was described as a flanking measure of the internal market and relates to the European, to the EU and to the European Free Trade Association, EFTA, and the European Economic Area. And of course, as the UK is neither a member of the EU anymore, nor a member of the EEA, nor of EFTA, it took the view that it shouldn't enjoy the UK the rights that the Lugano Convention bestows. So that's not an option at the moment. Does the 2005 Hague Convention apply? Well, I'll look at that on the next slide. If that doesn't apply, is there a reciprocal enforcement treaty? There in brackets are the countries which the UK has a bilateral enforcement treaty with each of those, insofar as EU members are concerned. And of course, if none of those things apply, including in a bilateral treaty, then enforcement will have to take place under local law. Go to the next slide, please. So the 2005 Hague Convention on the choice of court agreements, well, again, people will be familiar with this. The Hague Convention came into force, despite its being dated 2005, didn't come into force until 1st of October 2015, came into force in all EU member states and, interesting, Mexico. And now we have Denmark joining its own right, Singapore, Montenegro, and of course the UK. Again, you'll no doubt be familiar that the Hague Convention sets out rules for the validity and effect of exclusive jurisdiction agreements. And then, of course, once on the assumption that there is an exclusive jurisdiction clause that sets out recognition and enforcement provisions of judgments for contracting states designated in a given exclusive jurisdiction court agreement. So will it apply? Well, no, of course, but before 1st of October 2015, it'll be subject to local law, unless, of course, one of the European jurisdiction regimes applies. Between the 1st of October 2015 and 31st of December 2020, I've put the word possible enforcement there. The reason for that, unfortunately, is because so far as the UK is concerned, when it applied to join the convention in its own right, it made a declaration that the convention applied as it entered into force on the 1st of October 2015. So whilst the UK was still a member state, and that's been made good in statute by the 2020 Private International Law Implementation of Agreements Act. But not so, says the EU. Again, the European Commission has said that it hasn't entered into force the Hague Convention so far as the UK is concerned until it became entered into force as a member of its own right. In other words, after Brexit Day. So it only applies from the 31st of December 2020. So in other words, the UK courts will apply the 2005 Hague Convention for an exclusive jurisdiction clause entered into from the 1st of October 2015 onwards, whereas it remains to be seen whether EU member states will follow the European Commission's position and not apply the 2005 Hague Convention and for agreements entered into before the 31st of December 2020. Just before we leave the Hague Convention, the might be said that the downside of the Hague Convention, there are a number, but I think it strikes me that one of the main ones is that whilst final judgments and orders, so final injunctions, for example, can be enforced, interim judgments, such as an interim injunction, a freezing order, can't be enforced. And that contrasts with the recast Brussels regulation, which of course provides for interim protective measures to be recognised. So we go to the next slide, please. Okay, so moving away from judgment recognition and enforcement to insolvency recognition, what was the position pre-Brexit? Well, much like with judgment jurisdiction, it's very much still weathers EU law because the Insolvency Regulation 2015 continues to apply to main proceedings commenced in the EU or the UK on or before the 31st December 2020 and any secondary related proceedings. Now, when we're talking about secondary proceedings, we're talking about this respect of the same debtor opened after, there's potential for it to be opened after the transition period, so after the 31st December 2020, but providing the main proceedings were opened before that date. Again, practitioners on this call will be well familiar with the 2015 regulation, but of course the huge advantage to it is that main proceedings in one member state are given automatic recognition in all other member states without the need for a court order, which is obviously reduce costs and lessen the risk of parallel proceedings. What it is applied to, again, will be well known, but it applies to liquidations, administrations, voluntary agreements, and of course individual bankruptcy. And then no doubt again be familiar with the relatively recent case of Gate Group Guarantee Limited, where Mr. Justice Circa-Really ruled that restructuring plans, so the new Part 26A of the Companies Act, also those restructuring plans fell within the definition found in the regulation. So for those, of course, Part 26A only came in last year in June, so there won't be that many cases to which the judgment will have an effect. But for those that have been, to which the restructuring plan has actually been approved by the court in the intervening period between when it came into force and 31st December 2020, then the 2015 regulation will continue to apply to it and to any secondary proceedings. Next slide, please. So what is the position post-Brexit? Well, again, we of course lose the 2015 regulation apart from the caveats that I've just said in the last slide, or conditions I should say that in the last slide. So from 1st of January 2021 for, as it were, new fresh proceedings from the EU into Great Britain, and I use the word Great Britain there because Northern Ireland has its own provisions, although very similar to what they apply in Scotland and England and Wales, which is the cross-border insolvency regulations 2006. Now these will be familiar to practitioners who deal with countries to which they've also adopted the model law. And what the 2006 regulations does is give effect to those model law, which the United Nations Commission on International Trade Law adopted. What does the model law do? Well, it's set out fully in the 2006 regulation, but in essence, it sets out a fairly comprehensive procedure where assistance is sought from a British court by a foreign court or representative, an IP in foreign proceedings, by a foreign state in British proceedings, in concurrent proceedings where proceedings are both in parallel at the same time, or where foreign creditors and IPs have an interest in commencing or participating in British proceedings. So it's fairly all-encompassing. And it says there, I'm afraid, sorry, this last point has been missed off, but if foreign proceedings recognised in the UK as main proceedings, and existing UK proceedings are if foreign proceedings are recognised in the UK as main proceedings, then any pre-existing UK proceedings are stayed, and a foreign IP is able to administer and realise the debtor's assets located in the UK. It's incredibly wide-ranging provision, and in Article 19 has a provision for urgent relief that a foreign IP can apply for, and prior to their determination and application for recognition of the foreign proceedings. So before that's been determined, if there is an urgent need to protect assets of the debtor and in the interest of the creditor, an IP can essentially apply for any relief that would be available to a British insolvency officer, can be entrusted by the court with the administration and realisation of the assets, can stay execution against the debtor's assets, and can apply, including for a moratorium on legal claims that a debtor faces under Schedule B1 of the Insolvency Act. So it's a very powerful provision that essentially the British courts can provide assistance for foreign proceedings, provided the procedure set out in the model law is applied, and that necessitates, when I say British court, to the Chancery Division of the High Court, so far as England is concerned. Next slide, please. So what's the position with insolvency recognition in the EU post-Brexit? Well, as I've said, it's non-application now of the 2015 regulation. And of course, what the huge downside of that is the loss of automatic recognition in EU member states, and of course in the UK, meaning that UK office holders will need to have UK proceedings recognised in individual EU member states and or open simultaneous local insolvency proceedings in those states. The only other EU member states that have adopted the model law in their domestic laws are those four set out there. So save where you're dealing with proceedings that relate to or will relate to those four countries, it will be dependent on, of course, seeking local legal advice as to what each country's approach is to recognition and foreign and enforcement of insolvency proceedings. That, I appreciate, is a real whistle-stop tour of where we are. Haven't had obviously much time to dwell on that, but hopefully that gives those a refresher for those who are already well familiar, and at least an insight into the issues that one faces with respect to British proceedings, insolvency and judgments in respect to the EU. I'll now hand over to Tim.
And you'll be pleased to know that we're now at the end of the slides. Everybody is living in this Zoom world, and we're very grateful that you could spare some time. The meltdown, if I can call it that, as someone who practices mostly outside of Europe, that Europe is facing, or the rebuild perhaps is the fairer way of describing it, is a world that I have been living with in the Caribbean context for nearly 2 decades now. And one of the reasons that I qualified as an insolvency practitioner, I was a barrister for many years as well first, is because I'm firmly of the view that navigated properly, there's real potential and opportunity in all of this. So I spend a lot of my time really with the reverse problem to the ones that Chris was trying to help you with in terms of an explanation of the law. One of the problems that you grapple with in the Caribbean is the absence of clear statutory law, at least. And there is a wide variation between the Caribbean jurisdictions, some of whom you'll be very familiar, the Cayman, BVI, Bermuda, for example, if you count Bermuda in the definition of the Caribbean, where there's quite a lot of case law to help you understand the situation. But I spend a lot of my time helping either more established insolvency practitioners, people who are generally speaking accountants by background, avoid the need for recognition with practical solutions in terms of being able to roll out a strategy across the region. So I recently helped a liquidator of a Trinidad company do something else in the British Virgin Islands. And it was going to be such a headache to seek recognition that we just didn't do that. And we brought proceedings in our own right, the liquidator of the Trinidad company, and started those proceedings with the use of the good old statutory demand. A beautifully simple idea. I'm sure you all know that the statutory demand is not a prerequisite to presenting a winding up petition, but it's certainly a very effective tool to be used along the way, for the simple reason that failure to satisfy that is on its face a basis by which to allege insolvency of the underlying company. And that doesn't really change across most of the Caribbean. And I'm talking about what I would call the Anglo-Caribbean rather than the French Caribbean, the Martiniques, for example, because even the sovereign state Caribbean, so those who have been independent from the UK for a long time, have a very recognizably English system. So for those of you who are qualified as English trained lawyers, or British trained lawyers, I should say, you're going to be very familiar in the Caribbean systems. And it's no coincidence that so many of the contentious insolvency and judgment recognition lawyers in that region have a British training background. So statutory demand, as everybody knows, is just a way of flushing out the other side's position. You obviously get threatened with hellfire and damnation for abusing the system, but in the midst of their threats to you, they do have to explain why you're wrong. They do have to give a positive reason as to why the statutory demand is defective and why there is an underlying dispute as to the debt. So we regularly use it in the Caribbean as a way of flushing things out. It's extremely cheap, even if you end up paying some of the costs of a set-aside. There isn't a clear system of reciprocal enforcement. There's a better system if your judgment is a UK-sourced judgment with the overseas territories, and there are a list of those that are very easy to locate. Anguilla, BVI, Montserrat, Turks and Caicos, British Virgin Islands, Cayman Islands, Bermuda. I don't think there are any others. And those are, relatively speaking, more likely to have reciprocal enforcement arrangements in both directions with England and Wales. I quite often get asked about domesticating something into the UK, and it's a little bit easier from those places. One of the things that we are very often asked about in the Caribbean is how you can turn a US decision, a US damages decision, into something that is usable in one of the Caribbean jurisdictions. And the big problem is always an element of punitive damages in these situations. So if you can get to the source before they get their judgment in North America, very good idea to try and hive off the punitive damages element. A slightly reduced version of the same problem is trying to import an exemplary damages award from the English court system. The other thing that it's always worth reminding onshore lawyers about is that you shouldn't assume that there is the equivalent of a Section 25 supportive injunction in support of foreign proceedings. I was recently involved in some British Virgin Islands litigation about the absence of that, and that's now pending a decision in the Privy Council. But essentially there was no proper framework to grant freestanding injunctive relief in a place as sophisticated and as internationally recognized in litigation contexts as the BVI to an English, in fact, in that particular set of circumstances, a London Commercial Court set of proceedings. So don't assume that the apparatus that you rely upon and enjoy in the English context exists overseas. They're trying to plug that gap in the British Virgin Islands in a way that maintains their competitive position, because of course the reality is that some of these jurisdictions compete against each other for litigation. In relation to one other aspect that it's worth knowing about, and of course I say this in the context, as many of you will already realize, of Three Hare Court really having a very long history in the Caribbean region, mostly for governments, or very often for governments, but not always, is the difference between sophisticated jurisdictions like the English and Welsh jurisdiction and other European jurisdictions about litigation finance, and what you can do in the Caribbean jurisdictions. Very often, there isn't clarity on the law. And in fact, one of the advantages in being an IP as well is that I get the opportunity to try and fix the law, or at least clarify it, by bringing funding agreements into court to try and get them blessed. But even the big boys, as it were, in the Caribbean context, have had to be very creative in fixing this particular issue. For those of you who are familiar with the Cayman Islands system, they've recently brought into effect statute to plug that particular issue. It's quite well trodden ground in Bermuda, and BVI have recently had a decision called Essential, which signed off, as it were, on litigation funding arrangements within insolvency. But even within insolvency, it's not a given that you're going to be able to fund this. So for insolvency practitioners onshore, it's often a bit of a shock that it's not quite so clear offshore. I'm awaiting a decision where I was, in fact, the litigant trying to have a funding agreement signed off by the court. And because in the Turks and Caicos, where I'm an insolvency practitioner, licensed insolvency practitioner, they have the pre-1986 legislation. In fact, oddly, I can have colleagues of mine at my own firm out there work with me as my lawyers. So that's really all I wanted to cover in addition to the detail, the black letter law detail of Chris's. I think we have one or two questions, and I see, Chris, one specifically in relation to the first question that came in relation to Annex A. So if you wouldn't mind, you could handle that and then signal, because my phone is gone now, of course, when you've finished that, and I think I can pick up the one from Yuri Saunders.
Yes, of course. Yeah. Thank you, yes, for the question. Just for those who can't see it, there's a question about whether the restructuring plans under Part 26A of the Companies Act will be covered by the 2015 Insolvency Act and also by the Lugano Convention in circumstances where those proceedings, if I put it that way, or the form of insolvency proceedings are not listed in Annex A of the 2015 regulations. And it's a very good question, but that's something which was actually specifically dealt with by Zaccaroli in his judgment. And he came to the view that notwithstanding the fact that restructuring plans aren't in Annex A, obviously the UK didn't ask for them to be included. Of course, they were going through Brexit at the time. Notwithstanding that, the answer is found really in recital 10 and 11 of the 2015 regulation. And I'm not going to read out all of recital 10, but what it says is, recital 9 stipulates that only insolvency proceedings to which the 2015 regulation apply are those exhaustively listed in Annex A. But then in the next breath says the scope of this regulation should extend to proceedings which promote the rescue of economically viable but distressed businesses and which give a second chance to entrepreneurs. And it goes into quite some detail about what that means. And in effect, the High Court found that restructuring plans were absolutely on all fours with what was being sought to be promoted and the types of proceedings to which the 2015 regulations should support. So hopefully that, so I think it is arguable that the, not least because of course the High Court has determined it, that restructuring plans are subject to 2015 regulations. Of course, position is with respect to whether the High Court's judgment will be given credence elsewhere is obviously is a matter of debate. Hopefully that answers the question. If the question, I won't name her in case she doesn't want to be named, but wants to discuss this further, then we'll find contact details on the website. Okay, hopefully, I don't know if Tim, you can hear me, but this one's obviously directed to you next.
I think that might mean that Chris has finished.
Sorry, yes.
Again, I'm sorry for the sort of slight ship to shore here. I'm under pressure now to give us an erudite-looking answer. Yuri Saunders has asked a question about whether and to what extent there's reciprocal enforcement around the Caribbean. As many of you will know, it's a good question. As many of you will know, there is a sort of growing independence of the Caribbean, and there is a difference between independent states and those who fly under the wing, as it were, of either the British or the French. CARIBCOM, the economic union aspect of the Caribbean jurisdictions, is only going to mean that there will be more reciprocal enforcement across the region. But many of them at the moment are limited to legislation which has an approved list. And for some reason, New South Wales is always, from Australia, is always on those lists. I don't know who got in there or got a jolly to the Caribbean to scout all of these places, but they're always on the list. And then they have a second sort of analysis process that determines whether they're going to grant reciprocal enforcement on a case-by-case or state-by-state basis, according to the equivalent treatment that that country, the requesting nation, as it were, treats a decision outbound from, say, St. Vincent, which has that sort of legislation. There is always buried in that analysis, either on a statutory basis or on a common law basis, a degree of public policy, which is why the punitive damages issue is often so important, as well as, if you can at all avoid it, trying to enforce a default judgment. My heart always sinks. It's always my first question after whether or not there's a punitive damages element, as to whether the decision was obtained on a default basis. And if it is, there's going to be heartache. I had an interesting query, and I won't identify which Caribbean nation it was going to be enforced in, where a pretty severe sexual harassment case in North America had led to a punitive damages element. And the interesting issue as to whether or not the sort of bright line public policy against punitive damages could in any way be ameliorated by the reason why the punitive damages award was made. And it's yet to be decided whether there is scope for that. Well, if we don't have any other questions, Tim, Yes, that's true. But unfortunately, the sort of interlocutory game playing that's possible in the Caribbean can turn what should be a relatively straightforward go and look at the convention into a whole lot more than that. The Eastern Caribbean Supreme Court, as many of you will know, is a unified court system across several jurisdictions, which includes the British Virgin Islands. The benefit of having the British Virgin Islands in that court system is the sheer volume of commercial court work that deals with the onshore-offshore nexus. Is you have some really great jurisprudence, even though there are statutory variations between other members of the Eastern Caribbean Supreme Court circuit. The sheer output of that court provides a lot of very helpful guidance. And of course, everybody is busy marketing themselves from the Caribbean as arbitration centres or putative arbitration centres. So they're very keen to make sure that arbitral awards, either from there or inbound to there, are quite easily enforceable. And very often, for example, in the BVI, it's much easier to enforce an arbitration award than an ordinary judgment. Right, yes. Yes, well, there we are. In fact, great minds think alike. And although I'm afraid the scramble for the arbitrating parties' dollars have been hindered by many things, if it's not hurricanes, it's COVID lockdowns, it's been a bit of a false dawn. Tremendous investments have been made in some of these places to encourage that sort of work, even to the extent that there are express carve-outs to the work permit requirements for people involved specifically in arbitrations. But to state the obvious, until recently, to be involved in an arbitration, you had to actually get to these places. Things have changed a bit over the last 12 months or so for obvious reasons. But British Virgin Islands, for example, is quite a tricky place logistically to get to, especially if you can't fly between Antigua or Puerto Rico into the BVI. So yes, I completely agree with them being signatories, but it's not always as simple as that. Okay, well, I perhaps it's because I can't hear anything that the cheers for more are not coming through. So unless anybody has any other questions, or Chris has anything to add, which I won't be able to hear anyway, I think that may be it.
Just conclude by saying one thing, which is, as we put on the chat function, if you would like to email any further questions you think after this, or request a copy of the slides or recording, please do email marketing@3haircourt.com. But it just leaves me to say thank you very much for attending. Probably pleased that we've ended early on a Tuesday evening. So thank you again for attending. Goodbye.